Well, how you doing? We are on page 6. And we're going to start out with 6J, line 236. Buyer disapproval. If buyer, in buyer's sole discretion, disapproves of items as allowed herein, buyer shall deliver to seller notice of the items disapproved and state in the notice that buyer elects to either immediately cancel this contract and all earnest money shall be released to buyer, or provide the seller an opportunity to correct the items disapproved, in which case seller shall respond in writing within 5 days or blank days after delivery to seller of buyer's notice of items disapproved. Seller's failure to respond to buyer in writing within the specified time period shall conclusively be deemed seller's refusal to correct any of the items disapproved. If seller agrees in writing to correct items disapproved, seller shall correct the items, complete any repairs in a workmanlike manner, and deliver any paid receipts evidencing the corrections and repairs to buyer 3 days or blank days prior to close of escrow date. Line 246. If seller is unwilling or unable to correct any of the items disapproved, buyer may cancel this contract within 5 days after delivery of seller's response or after expiration of the time for seller's response, whichever occurs first, and all earnest money shall be released to buyer. If buyer does not cancel this contract within 5 days as provided, buyer shall close escrow without correction of those items that seller has not agreed in writing to correct. Verbal discussions will not extend these time periods. Only a written agreement signed by both parties will extend response times or cancellation rights. Buyer's failure to give notice of disapproval of items or cancellation of the contract within the specified time period shall conclusively be deemed buyer's election to proceed with the transaction without correction of any disapproved items. 255. Line 255. Notice of non-working warranted items. Buyer shall provide seller with notice of any non-working warranted items of which buyer becomes aware during the inspection period, or the seller warranty for that items shall be waived. Delivery of such notice shall not affect seller's obligation to maintain or repair the warranted items. Line 258. Home warranty plan. Buyer and seller are advised to investigate the various home warranty plans available for purchase. The parties acknowledge that different home warranty plans have different coverage options, exclusions, limitations, service fees, and most plans exclude pre-existing conditions. Checkbox. A home warranty plan will be ordered. Checkbox buyer or checkbox seller with the following optional coverage. To be issued by, at a cost not to exceed, to be paid for by buyer or seller. Check whichever box. Buyer declines the purchase of a home warranty. There's a box to check if the buyer declines the purchase of a home warranty. 265, walkthrough. Seller grants buyer and buyer inspector reasonable access to conduct walkthroughs of the premises for the purpose of satisfying buyer that any corrections or repairs agreed to by the seller have been completed, warranted items are in working condition, and that the premises is in substantially the same condition as of the date of contract acceptance. If buyer does not conduct such walkthroughs, buyer releases seller and brokers from liability for any defects that could have been discovered. Seller's responsibility regarding inspections and walkthroughs. Seller shall make the premises available for all inspections and walkthroughs upon reasonable notice by buyer. Seller shall, at seller's expense, have all utilities on, including any propane, until close of escrow to enable buyer to conduct these inspections and walkthroughs. This is part 7, remedies. Line 272, cure period. A party shall have an opportunity to cure a potential breach of this contract if a party fails to comply with any provision of this contract. The other party shall deliver a notice to the non-complying party specifying the non-compliance. If the non-compliance is not cured within 3 days after delivery of such notice, cure period, the failure to comply shall become a breach of contract. Line 276, breach. In the event of a breach of contract, the non-breaching party may cancel this contract and or proceed against the breaching party in any claim or remedy that the non-breaching party may have in law or equity, subject to the alternative dispute resolution obligation set forth herein. In the case of the seller, because it would be difficult to fix actual damages in the event of buyer's breach, the earnest money may be deemed a reasonable estimate of damages, and seller may, at seller's option, accept the earnest money as seller's sole right to damages, and in the event of buyer's breach arising from buyer's failure to deliver the notice required by Section 2B, or buyer's inability to obtain loan approval due to the waiver of the appraisal contingency pursuant to Section 2M, seller shall exercise this option and accept the earnest money as seller's sole right to damages. An unfulfilled contingency is not a breach of contract. The parties expressly agree that the failure of any party to comply with the terms and conditions of Section 1D to allow close of escrow to occur on the close of escrow date, if not cured after cure notice is delivered pursuant to Section 7A, will constitute a material breach of this contract, rendering the contract subject to cancellation. That's the end of page 6, and we're going to start page 7 on the next video. Thanks for hanging in there, folks, and we'll be back